Buenos días a todos.
Good morning, everyone. El doctor Julio Rodríguez, the doctor has the word, the president of the Academy of...
Señores académicos, individuos de número de la Academia de Ciencias Políticas y Sociales, miembros de otras academias nacionales que hacen vida en el Palacio de las Academias, señores, señoras, el evento de hoy tiene una serie de características particulares que lo hacen más atractivo frente al público, no solamente nacional, sino también internacional. Desde este punto de vista, las conferencias van a ir siendo traducidas al idioma inglés, tanto en la plataforma Zoom como en la de YouTube. En este sentido, hay que agradecer a Universitas el esfuerzo que se ha hecho para lograr esto, y también muy particularmente a la abogada Mariana Karina Escolaro Pereira, abogado graduado en la Universidad Católica Andrés Bello, que forma parte del grupo de investigación del doctor Canova, que nos va a ayudar en la traducción. La significación del evento justifica todo el esfuerzo que se está realizando por lograr que nuestro evento llegue a las personas que no lo pueden entender en el idioma en que se está produciendo originalmente. El Essequibo representa para los venezolanos una vieja reivindicación territorial ligada a valores, sentimientos y anhelos vinculados con la venezolanidad. De esta perspectiva, en la que confluyen creencias y realidades, el territorio es un espacio en tanto que él es portador de identidad. En un evento como el que nos ocupa en el día de hoy, pretendemos explicar nuestra relación con el Essequibo, no solo desde el punto de vista de la ciencia de la naturaleza, con lo cual hablamos de los hechos a partir de las causas, sino también desde la óptica de la ciencia del espíritu, como el derecho, lo cual nos obliga a comprender las acciones a partir de razones. El esfuerzo que hoy realizamos, a cuya cabeza está el doctor Héctor Faúndez Ledesma, retoma un tema constante en la agenda de la Academia de Ciencias Políticas y Sociales. En efecto, el académico Tomás Enrique Carrillo Batalla, al cual rendimos merecido homenaje este año, señalaba
It appears that the president of the Academy has difficulties with his connection.
Sí, continúo. La controversia con respecto al tema de la reclamación venezolana, la fecha en que las academias nacionales de Ciencias Políticas y Sociales y de la Historia realizaron bajo mi coordinación este ciclo de conferencias. Me refiero a lo señalado, como habíamos dicho antes, por el doctor Tomás Enrique Carrillo Batalla. Y adicionalmente, con gran clarividencia en la presentación de la obra que comentamos, señaló el doctor Carrillo: si miramos al problema en su estado actual, cabe afirmar que pese a las limitaciones y defectos del Tratado de Ginebra, al país no le queda otra vía que continuar buscando la salida que ofrece este instrumento legal. Si se agotan sus posibilidades sin que se haya alcanzado la solución, habría que pensar entonces en otra fórmula, pues lo que sí es cierto es que el pueblo venezolano no aceptará nunca conformarse con un despojo contrario a la tradición histórica, a toda norma de justicia y a los principios fundamentales del derecho internacional, cuya base es el libre consenso de los pueblos y jamás la fuerza y la violencia. En la misma obra que comentamos, el ex canciller doctor Ignacio Iribarren Borges realizó el siguiente comentario: en muchas oportunidades me han preguntado lo que pienso sobre el futuro de nuestra reclamación de tierras en la Guyana Essequiba. Invariablemente he respondido que creo con firmeza en la posibilidad de un acuerdo que satisfaga el interés nacional. Pero para alcanzarlo es menester que la voluntad de toda la nación respalde el esfuerzo continuado e inteligente de los que dirijan la gestión. No me atrevo a vaticinar el tiempo que se requerirá. Depende de multitud de circunstancias, muchas de ellas determinadas por la coyuntura internacional y el porvenir e importancia relativa a nuestra región. El tema coyuntural referido por el doctor Iribarren Borges cobró sentido en otros momentos con el afianzamiento de la relación Venezuela-Guyana como parte de todo un esfuerzo de la diplomacia venezolana en el Caribe. Tal situación fue mencionada en el pronunciamiento de la Academia del 22 de octubre de 2003. Por su parte, el doctor Germán González Oropesa, sacerdote jesuita, refiriéndose al laudo de 1899, resaltó que el mismo está rodeado de una abrumadora evidencia de que fue un compromiso en una decisión legal. Más adelante señala: me voy a detener en las razones políticas que explican que el laudo sea una componenda de intereses políticos de las potencias. Ciertamente que el manejo del Essequibo ha originado profundas frustraciones en la sociedad venezolana. Pareciera que los eventos siempre pasan por encima de nosotros. Con algún grado de frustración, señaló el académico Isidro Morales Paul, y se preguntaba, ¿por qué Venezuela cada vez que tiene un problema tiene que inventar las soluciones? Se llama a un negociador y se le dice: diseñe la solución, discútela, aplíquela, que si tiene la razón usted, interprete debidamente el pensamiento del presidente de la República. Pareciera que este tema no hay nunca un final, primero para ver un resultado, señalaba el ministro Aranda a Fortique en 1847. Si quisiéramos tener un resumen del tema, pudiéramos recurrir a las 37 conclusiones formuladas por el doctor Isidro Morales Paul en la conferencia pronunciada en la Academia el 28 de septiembre de 1999, con motivo de cumplirse 100 años del laudo arbitral del 3 de octubre de 1899. Pero la historia no se detiene ahí. Los problemas de Guyana han venido generando a lo largo de los años, hasta el día de hoy, sendas respuestas de la Academia ante lo que se ha considerado actitudes del gobierno de Guyana contrarias a los intereses venezolanos. Así como los académicos del pasado se ocuparon del tema, los de hoy lo vienen haciendo con el mismo vigor y sentimiento nacional. Sin ir muy lejos, el coordinador del ciclo de coloquios que hoy iniciamos, doctor Héctor Faúndez Ledesma, en un libro reciente de la serie Estudios de la Academia, aborda con un enfoque científico e impregnado de un profundo realismo la situación frente a la cual se encuentra Venezuela a raíz de la demanda de Guyana contra Venezuela. El siguiente párrafo refleja la motivación que mueve al autor. Mi intención es analizar los hechos y el derecho en forma tan desapasionada como sea posible. Pero desde ya pido la indulgencia y la comprensión del lector si no siempre soy capaz de lograrlo y si a veces, incluso sin verlo, cruzo la línea para ponerme al lado de mi segunda patria, una de las partes de esta controversia. El académico Faúndez está claro el rompecabezas frente al cual nos encontramos. En tal sentido expresa, en este rompecabezas en que la competencia de la Corte puede estar sujeta a muchas reglas distintas para cada Estado, habrá que encontrar cuál es el lugar que corresponde a la disputa por el Essequibo. Pero en esa interrelación de distintos elementos que se mezclan en este conflicto, se puede constatar que el arreglo judicial no es necesariamente el recurso adecuado para resolver cualquier controversia y que a veces es una fuerza que sobra. En lo que la obra citada resalta con palmar claridad es el elemento territorial. En tal sentido, señala el académico cuya obra comentamos, la presente disputa entre Guyana y Venezuela no es una controversia jurídica sobre si la Corte tiene o no competencia, sino una controversia territorial, que las partes han acordado que debe ser resuelta mediante un arreglo amigable, buscando soluciones satisfactorias para el arreglo práctico de la misma. Frente a la pregunta que nos hacemos todos los venezolanos con respecto a cuál debe ser la posición frente a la demanda de Guyana, Faúndez adelanta una opinión que resume parte de lo que debe ser nuestro actuar futuro. No hace honor, dice Faúndez, no hace honor a los compromisos internacionales, no hacer honor, perdón, a los compromisos internacionales no forma parte del ADN de los venezolanos. A menos que alguien tenga otra solución, lo patriótico será seguir defendiendo los derechos de Venezuela, si es necesario inclusive en la fase de fondo ante la Corte Internacional de Justicia, respetando las reglas del juego y aceptando que tal vez no siempre tenemos la razón. Michel Fouché, refiriéndose a las fronteras y a los territorios, señala, se puede sostener que las fronteras han sido inventadas por los hombres de Estado y por los militares para oprimir a los pueblos. Aquellos que tienen una noción clara de la frontera no se dejarán encantar por tales manifestaciones de imaginación y pensamiento especulativo. Este señalamiento liminar de los geógrafos franceses Jean Brunet y Camille Bollot en la geografía de la historia de la guerra y de la paz de 1921 se refiere a los límites del Estado, que es el sentido primario y siempre pertinente del concepto de frontera, con el objeto de profundizar algo de lo señalado y las dudas que nos genera la relación con Guyana y la solución a un problema que nunca termina de definirse. Hemos convocado a un grupo de expertos notables en el conocimiento del tema Essequibo. En este sentido, la corporación manifiesta su profundo agradecimiento al coordinador del evento, a los expositores y a los moderadores. En general, los problemas limítrofes son lo mismo, pero las circunstancias difieren radicalmente. No sabemos qué nos depara el futuro, pero con Ana Arendt podríamos decir que las construcciones de los futurólogos solo se dan en un mundo donde nada importante sucede. Muchas gracias.
Thank you very much, Mr. President, for this first session of this lecture series coordinated by the Social and Political Science Academy. This conflict has over 180 years and is still pending a decision before the International Court of Justice. We wanted to remember what has the Academy done about the Essequibo territory. To that effect, we're going to have the presentations of 5 experts: Professor Arria, Ruan Santos, Humberto Romero-Muci, Eugenio Hernández-Bretón, and Carlos Ayala Corao. Because of their trajectory and experience, all of them are sufficiently known and they don't need presentation. The first 4 are former presidents of the Academy, and in that condition, they had the task to be the voice of this position, to transmit to the country and the international community what is happening. And also alert the country every time it was necessary to defend our sovereignty. Expired from 1995 to February 1999. Professor Carlos Ayala was the facilitator of the Venezuelan government in the process of the Essequibo, promoted by the Secretary General of the United Nations to provide a solution to this controversy. It is then renowned Venezuelans that have contributed notably to the defense of the rights and interests of Venezuela in the Essequibo. I will leave with you Dr. Arria, former president of the Social. Dr. Cova. Thank you. Hector. I'll start. Dr. Julio Rodriguez Berresbestia, President and other members of the Academy, Mr. Scholars of the other national academies, professors and students of different universities, public and private, all that are here on this lecture series of Essequibo. I'm not going to say too much on the precedents of this conflict between Venezuela and Guyana. We're having some connection issues. And other topics will be covered by other presenters. Located at the top of Mount Roraima, So for that, I have invoked documents as legitimate title for the document. That conflict was decided in October 3rd, 1899 by arbitration award of Paris, a decision that was decided in favor of Guyana by an ad hoc tribunal that was settled in motive of the treaty signed between Venezuela and England and the UK February 2, 1990. With death of Severo Mallet in 1948, one of the lawyers, American lawyers that was defending Venezuela, he was referenced that there were hidden denial till then of what was the reason why the arbitration award took the territory of Guyana from Venezuela. From this finding, Venezuela found this award as void. That took to the sign of the Agreement of Geneva, 17th of February, 1966. A few months after the signature of the Geneva Agreement, we have connection issues. It seems that I lost connection. Please wait a moment. A few months after the signature of the Geneva Agreement in April 1976, Dr. Andrés Aguilar Mosky, whose name he has given to our library, handed Dr. Rafael Caldera, who was president at the time, 3 years after the signature, a memo in reference to that award. In that memo, between other things, he was pointing out Dr. Aguilar to Dr. Caldera was saying the following: there's no opportunity to discard this possibility that these points or others could not be an acceptable agreement to both parties. There's no other option than judicial agreement. According to an official interpretation, the agreement implies the recognition of the United Kingdom to the eventually new state of Japan, the competence of the International Court of Justice. Even though when it's this, some people that think that that interpretation is debatable because the agreement does not make express reference to the International Court of Justice, let's guess that this issue is not discussed if the court declared itself competent to know about this issue. In this regard, the court can adopt the point of view that its competence limits exclusively to examine the controversy between Venezuela and the Kingdom, that third, because of the consequence of the Venezuelan contention that the award of Paris is void according to the terms of Article 1 of the agreement. He keeps saying in that memo, in other words, the court can say that solely that the validity of that award, we have to admit that they recognize the existence of the controversy. Because others have convened that the procedure, theoretically at least, it could be the effect of having without its effect. That way, the Venezuelan position is improved, is leveraged. Without a doubt, the more complicated part of the agreement is that it will be unfair to exaggerate. The agreement does not allow to affirm that the questions that issues going to be resolved necessarily by the means that were. Now we can allege before the International Court of Justice the authority of that agreement, the Paris Award of 1899, according to what it was disposed in the first paragraph of the agreement. none of what established in this agreement be interpreted as a renounce or diminution from Venezuela to the United Kingdom and Guyana of any reclamation that it has over the territory. Or judging its position in respect to recognition or non-recognition about the right to claim its sovereignty of that territory. He keeps saying, Dr. Aguilar, that Venezuela could make the argument that the celebration itself of the agreement is a recognition, tacit recognition, that it has not been an omission of the United Kingdom to accept the procedure to make this. It could also be argued that the internal conditions and international that were present in 1899 and the following year, that later some documents confirm the suspects that Venezuela had, that it has been victim of an arrangement between two big countries. Nonetheless, it is need to say that the court could declare declare the defenses of the United Kingdom in order without entering even to the examination of our argument. This memo was made by Dr. Aguilar 2 months after the Agreement of Geneva was signed. There's not been few of academics that have occupied and have given their opinions through articles, publications. All of them have been duly published in our newsletter. Between those articles, Carlos Sosa Rodriguez in his article. Likewise, we have to highlight the opinions of Tomás Enrique Castillo Batalla, Venezuela, Pedrejos Lara Peña, Isidro Morales, Tomás Polanco Alcántara, Pedro Niquen, Gabriel Ruan Santos, Carlos Ayala Corao, Humberto Romero-Muci, Hector Faundes in many of the conference and publications. Among the events made by the Academy, we cannot stop mentioning the lecture series organized in 1988 in conjunction with the Academy of History, under the initiative of Dr. Tomás Polanco Alcántara, with coordination of Dr. Blas Brunicelli, Tomás Enrique Batalla. Conferences that were published in our series of events under number 2. One of the conferences that were published there, who was given by Dr. Isidro Morales, that one was also cited by our former president, Gabriel Ruan Santos, in his brilliant work denominated The Prescription Clause of the Controversy between Venezuela and Great Britain on the Guayana Essequibo. Adhering to the thesis of Isidro Morales Paul, containing an academic analysis about the border issue between Venezuela and Great Britain. Also, that prescription clause was settled in 50 years, applicable to all possessions prior to the arbitration award. According to this law, to determine the divisory line between Venezuela and Guyana, making prevail the principle of uti possidetis facti and ite possidetis juris, meaning the situation of facts over legal time. Concluding, I'm gonna do a brief reference to the events of the Academy of the Essequibo, when I had the honor to be president of this corporation. In October 2013, we subscribed to pronouncements. One, backing of the Inter-Academic Committee for National Academies. In the first, the Academy manifested preoccupation of inexplicable silence of the national government in front of the actions taken by the Guyana in violation, direct violation of the Geneva Agreement. specifically about the Atlantic front, which Venezuela has absolute right of sovereignty over territory, continental territory, territorial sea, and continental platform. We highlight that international law, Venezuela, every state has the right over territorial sea of 12 Navy miles. And also to take advantage of the economic resources of the surface and the bottom of the sea. And also the continental platform, which extends also, we made protests to the violation from the government of Guyana because of violation of national sovereignty. In the individual communication of our academy in 2013, October 22, we highlight the interception of the National Navy of Botequit Perdona, congratulating for complying with its duty and to present the communication between to the Ministry of Foreign Affairs, saying that Venezuela expressed its profound preoccupation because of the way of foreign boats were authorized by the government of Guyana to go into the territorial sea of Venezuela and economic exclusive zone. What would dominate the problem of the Guayana Essequibo, present and future. Who was the ambassador of Venezuela in Guyana, Raíz Morillo Daher, who was visited the stone in reclamation years before the celebration of that colloquium. The important presentations and opinions that were emitted in that conference were published in a newsletter of the Academy. As we all know, the controversy the Geneva Agreement established that all parties have to find satisfactory solutions to the controversy, so it can be resolved in a way that is both acceptable to all parties. I manifest my support of the opinions of the scholars Isidro Morales Paul, in reference to the prescription clause that was contained in the Eritrean War of 1897. I finish with this quote of the agreement. Even though the lack of transparency of the process and the lack of motivation, formal motivation of the war does not reflect expressly what it was a subterfuge, a hidden strategy that ended up in a political conduct of the governments of Great Britain and United States. That they force upon the agreement an obscure interpretation of ius deposietis juris and ius deposietis factis. Thank you very much, Dr. Luis Cova Arria. Now it corresponds to Dr. Gabriel Ruan Santos, who is former president of the Academy. Please go ahead, Dr. Ruan. Thank you very much, Dr. Foundes. Honorable President and other members of the Political and Social Science and the organization of this event. I'm going to refer as well to the historic background of the intervention of our academy in the task to take back the territory of Guayana Essequibo. The academy has been active in the reclamation to recover the territory many years ago. It even takes part on the essential doctrine of the institution. However, it wasn't always like that, because there were stages of the history. The academy kept relative science regarding their claiming. Let's refresh then this. After the publication of the previous Paris Award, who was intended to resolve the controversy, the territorial controversy between the border of Venezuela and Guayana Británica, the Venezuelan government, the public national opinion, other governments of Latin America, and even the opinion of the United States denounced the Paris Award because it was void, because it hasn't been adjusted to the requirements of the arbitral agreement, because it has ignored the rights of Venezuela, because it was the result as well of a political politic that was made behind the Venezuelan government and coercion over the Venezuelan government and the arbitrators. Because also this award was immotivated, violation to due process, and because it incurred in abuse of power. These facts that were described with some dramatism by Dr. Rafael Seijas, who was a jurist and knowledgeable of the international, public international law, and foreign minister of Guzman Blanco, and also witness of what happened. Even though this nudity of the word was denounced, there were pressures that were exercised by the government of the United States and Great Britain since the 1900s. And then the government presided by General Cipriano Castro since the 1900s, and in particular in 1905, he was obliged to execute that award of 1899 through the subscription to an agreement between Venezuela and Guayana Británica. And then after the following governments kept a relatively passive position in its reclamation. However, disappearance of surrender. However, even though this appearance of surrender, the pressure didn't stop, and the threats and coercion over our country from European countries and United States, especially when our shores were blocked. The implementation of the rail and refinance of the German bank or other particular contracts. Those agreements were not legitimate. To lift the block, there were constituted a series of mixed commissions that came from the Washington Protocol to pay the debt, which was also already diminished by the Revolución Libertadora, supported by foreign enterprises. It's possible to affirm that Venezuela was in a state of necessity that compelled her to accept impositions with the goal to avoid an invasion from the Americans. From that position and the took of power of Juan Vicente Gómez as president of the Republic, given the support that was given by the States in the coup d'etat that took out the General Cipriano Castro, the government of Venezuela consolidated its position of a passive position before the claiming and complied with the Paris decision and the agreement of 1905, which established the demarcation of the border with the then British Guayana. So in 1915, the Academy, with the based in a law project, a field project that was presented before the fossil hill for tool, the Academy celebrated its first session in 1917. Until that date, we could not express in public any reference to the agreement. With difference to other institutions, the Political and Social Science Academy was born as an institution that was counseling the legislative rather than the public administration. So then it could explain that that context in which the Academy was born had explained the activity for many years in support of General Juan Vicente Gomez. Dr. Rogelio Perez Perdomo has a skeptical position, and he described this way: that this was unexplored territory, furthermore judged as a big mistake, national mistake, having abandoned this place around the 1940s. Even though with the help of historian Rafael Maria Baral, they were very close to reach an agreement until the unexpected death of Martic. We believe that he was the main sponsor of the creation of the Academy, which is very representative of the passive attitude of the Academy before the regime of Gomez. After the 80s, a lot of multiple controversies, legal controversies, the Academy joined the public opinion with many colloquiums, pronunciations that were gathered in the institutional doctrine from 1980 to 2012 and the newsletter of the Academy, and more recently in the brilliant recompilation gathering by Dr. Humberto Romero-Muci that covers the agreements and pronunciations from 2013 till 2019. Given that the scholars that join me here also is gonna talk about the activity of the Academy, I'm gonna focus myself in this intervention to highlight some aspects of this of the cycle of lectures that were organized by the Academy, joined by the National Academy of History in the year 1981. Highlighting two publications of our Academy under the coordination of Tomás Enrique Carrillo. There were some presenters participating in that cycle of conferences. The former Ministry of Foreign Affairs, Marco Falcón Briceño and Ignacio Iribarren Borges. The number members of Academy, Isidro Morales Paul, Pedro Morales Peña, René Solá. And the historians Herman González, S.J. and Rafael Armando Rojas, by the National Academy of History, all under the coordination of Dr. Tomás Enrique Carrillo Batalla and Blas Brunicelli for both of them. The interventions of those foreign ministerial affairs of the governments of Rómulo Betancourt, Raúl León, and Iribarren Borges. They brought deep knowledge about the fact of the led to the independence of Guayana and the celebration of the Geneva Agreement. Falcón Briceño described the evolution and reactivation of the claim and told the moment which, in his judgment, changed negatively for Venezuela the support of the state. There was a rise because of the problems from the wars of England in South Africa, in the south of Africa. And also the popularity that our position had in the United States. After he defends with humility the value of the Geneva Agreement as the best diplomatic achievement of Venezuela before this unavoidable independence of Guyana. Iribarren Borges, apart from highlight the relevance of the Geneva Agreement, defend the legitimacy of the diplomatic pressures of government of Leone in front of the relentlessness of the Guyana government and its denial to negotiate and retire all support to the Geneva Agreement. The members of the Academy, of this Academy, they added with deep legal analysis the position of Venezuela before this recall. Doctors Efraín Sánchez y Venezuela, they criticized the Geneva Agreement because it didn't present a conflict with England, but it gave priority to the relations with Guyana without going to the substance of the matter. Doctors Carlos Rodriguez and Isidro Morales Paul describe in detail all the legal story of the territorial dispute that existed between Venezuela and the nullity of the war of 1899. That could be defended before any judicial jurisdiction without recognizing the significance of the Agreement of Geneva. In their interventions, I highlight the idea that it has been a mention of Venezuela in front before the Paris Agreement, and resuming the discussion over the border between the two countries. Dr. La Peña and the Jesuit father Herman González highlight the attack to the validity of that Arria agreement and what England and Russia and the role that they played and the United States in the process of the treaty. That activity was directed to hide the lack of legal validity of those British titles over the territory of the Essequibo. With all these lectures, I could get to know in depth what it seems to be the legal argument of the formal discussion. The prescription clause of Article 4 of the Paris Award 1897. That way, I give the floor to the other scholars that will complete the positions about the value of the activity of the Academy before the historical reclamation of Venezuela over the Guayana Essequibo territory. Thank you very much. Thank you very much, Dr. Ruan. Professor Carlos Ayala has manifested that he has to travel in a couple of hours. And he has asked me to consider the possibility to move his intervention forward so he can continue with the preparation. So, if the other presenters don't have any problem, I give you then, Professor. Please, Professor Ayala, go ahead. Thank you very much, Dr. Foundes. Good morning, everyone. Mr. President of the Academy, fellow scholars of the Academy, the Universitas platform, Dr. Mariana Scolaro, that today is supporting us with the simultaneous translation of this conference. and the audience in general. I want to start thanking the possibility to have joined you today in this conference, and at the same time tell you the honor it is to me to be joined by these notable scholars. I'm gonna make a reference to the historical work of the Academy that has been referenced already. I'm in the second part. I'm going to highlight one of the dimensions that have occupied the Academy is its work into the claiming of the Essequibo territory. In the first place, like you have seen, this is a subject that our Academy has had a constant preoccupation since its beginning, independently in the position that was taken on the first moment. And as you have seen, it has been object of a series of publications, research, expositions, like it was announced by Dr. Faundes. Some of those scholars have been ministers of foreign affairs, and it has dealt with this question, and others has been counselors to the Ministry of Foreign Affairs. Others we have been facilitators of this process. And what I meant is, as with interventions, the Academy has had a role as an institution in set a position about this historical claiming. I want to start making reference to a very important work, not only because of its own content, but because of the moment in which it was organized. Is the incorporation work of Dr. Carlos Ayala as early as 1938. I want to signify this work because it touches on many points that we're talking about. Even before the Geneva Agreement, in this historical work, the baseline was set for the nullity mission of the award of Paris. It's a very complete work that starts with the independence of the colonies. Even what it signified until that moment, the legitimacy of the claiming of the of Venezuela over the territory of Essequibo. I try to explain to everyone who is listening the positions of the positions that the Academy has had over this claiming. I will try to share my screen to show you a first map. You have to see precisely what it has been. I don't know if you have the map on the screen. Just for you to see what is the continental territory, the continental zone area in reclamation. And today, even though we're focused on the reclamation of the Essequibo territory precisely because the arbitration award of 1899, which was void, and because it's void, it cannot represent a legitimate title to exercise sovereignty. As it was said in the morning of today, in a controversy that is territorial based. The problem is that, as you have seen, the Academy has made a lot of pronunciations about the solution of the controversy, the territorial controversy. That satisfactory solution for the practical problem of the controversy. And this has to do with the conflict over the nature is territorial. And the government that today is the Cooperative Republic of Chile. And how they recognize the potential of unity of the arbitration award to seek a practical solution. The purpose of the Geneva Agreement leaves behind the legal debate over the nulity or not of the arbitration award of parties. And enters to look at practical solution. Looking also the competence of the International Court of Justice to establish the validity or not of the arbitration award, which we cannot find in the proper Geneva Agreement of the purpose, but simply so you can visualize the continental territory of the and continental territory of the zone in reclamation. So let's move forward to the blue part of the map. Venezuela basically has duplicated its territory with all the limitations that we cannot see complete here of its Caribbean front, the front of the Caribbean Sea. Isidro Morales Paul had a responsibility, a role in that delimitation, especially the delimitation of the Atlantic front on the zone between Trinidad and Tobago and Venezuela. Not only the states focus on the continental territory, but also the possibility, certain and according to the law of the sea and the contemporary international law, that to extend their sovereignty to the sovereignty on the sea, on the territorial sea, the economic exclusive zone, the continental platform, and the possibility to extend even in the platform territory as we did with Trinidad. Then, as you will see, the pronunciations, declarations of the Academy, that Academy has made officially, not only in their work, have their twofold. The reclamation of the territorial of the territory, which is framed basically on the Geneva Agreement, and within the Geneva Agreement and the mechanisms of practical solutions to the controversy. They're promoted by the Secretary General of the United Nations that had to do. Now, after the mixed commission, the protocol of Puerto España, it has to do fundamentally to the mechanism sui generis, which is the mechanisms of the good officers for the parties that were assisted, or the those who were called the facilitators. So that mechanism, the diplomatic mechanism, through which the solution of the controversy were taken up on, through those mechanisms. The Academy, although through its organization, did a number of observations. I'm going to center in the subject of the historical pronunciations that the Academy made. As early as 2011, and we know already all the activity publications from the 80s and the publications I already referred to you. But as early as 26 October 2012, it's been over a decade that we have been occupied on this topic. Made a reference over the pronunciation of Guayana in reference to a pretension of them they presented before the United Nations in the Conference of State Parties and the Convention of the Law of the Sea to extend the exterior limit of the continental platform until the 350 nautical miles, without taking into consideration their limit and the right to Venezuela. So we call the attention on the importance of giving a solution to the territorial controversy, as well as the pretensions of the Guyana government. So they were done by the diplomatic representative. This pronouncement is going to be very important because it's going to set, and I want to highlight that pronouncement of the Academy. That Dr. De Sola, as was also former president of the Academy, the series of pronouncements that are part of the role of the Academy, in which you could see that the existence of the Academy, as I was saying, it's been at first place, the practical solution, the satisfactory solution through a diplomatic solution of the Geneva Agreement. So that's why we alert about the expression of the will of the government of Guyana to request the Secretary General of Nations the revision of this controversy before the International Court of Justice. And we have alert about the lack of jurisdiction and independence of the International Court of Justice because of different reasons, legal reasons, motive being the first main one, that none of the countries involved has accepted jurisdiction of the court, but furthermore, the Geneva Agreement have the objective, the goal to give a practical solution to the controversy versus what it will be legal. But after the Secretary General of United Nations sent this issue, the Academy has had the position to set a strategy, judicial legal strategy. So the rights could be better defended. In that sense, since very early, the Academy has insisted in presenting this case out of importance before the Secretary General of the United Nations. But in the case that it was sent to defend the substantive matter of the nullity of the Paris Award. The Academy thought that it was important to study to present a countersuit around the Geneva Agreement. Now, the second part of this historical position of the Academy, since very early, has to do, as Dr. Luis Cova has remembered, it has to do with the claim before the invasions of the current sovereignty of Venezuela. This is leaving aside what we can achieve with the territorial reclamation, that territorial continental territory generates a projection in respect to its maritime territory. As we have said, and allow me to show you the map that you have here. In front of the positions, you can see that if we take Punta Barim, the continental zone, more to the east, the projection of Guyana is not that is a parallel projection from the line of the limit. Look where their concessions were given. The conflict will be focused from the Atlantic front to the Atlantic. The intention is to close the channels of the Orinoco River. The projection from Delta Macuro and what is the continental territory precisely towards the territorial sea to the economic exclusive zone. Look as well that contrary to the blue line that you are seeing, the pretensions. The pretensions that you have seen with the flow. And it has actually, in its initial exploration, but how that blue line that it pretended to close the projection, and what it should do according to the principles of international law, or at least a line that is at the same position, that is equidistant, taking into account the character of the territorial sea and its projection. And its projection to the depths of the sea at the end of the continental platform until the Talud. So that's why it's important to handle two topics. Likewise, the Academy has done its position about the territorial recognition down there of the Essequibo territory. The Academy has also insisted that in this moment, taking aside that reclamation of that territory, we cannot allow to lose what is not in discussion. And what is not in discussion? It cannot be in discussion this idea of a temporary point while we settle the projection of our territorial continental territory, and the projection to 200 miles, and the projection to the Atlantic Talud of 350 miles. But we can see now how precisely Guyana has pretended. Look here, the extension is going to be taken. That extension is pretended to be done in Venezuelan zone. We congratulate the activation of the Venezuelan Army, but then we make some observations about how that's working. But the necessity to patrol all that zone, and the necessity to do not accept precisely that is the pretension of Guyana, while we attend the situation of the continental territory of Guyana. So Venezuela has to affirm its sovereignty, and that is precisely the call of attention that we have done very early the very first declaration of Guyana, first attacks of Guyana and the need of its preservation. One of the that it was the fleeing vessel Nayera, its location in front of the continental territory. So it cannot be pretended to not recognize the rights that belong to the continental territory of Venezuela in its projection of its Atlantic front. As you can see, we have a border with Trinidad and Tobago, a delimitation that was taken, a delimitation that was done between the maritime areas. So it cannot be pretended, as Guyana has done, to close the projection, see that all the shores of Guyana have to have their projection towards the Atlantic Ocean. Here in this map, by the way, this map has been borrowed by Dr. Romero-Muci. The projection here we see from one side at close Barbados and Trinidad, and a projection of our delimitations. You can see here in this delimitation how Guyana can wrongly pretend to close the projection of our Atlantic front to the sea. Well, basically, that justifies that all the pronunciation of the Academy we have had insisted in applying and explore the mechanisms of international law to reject a delimitation and unilateral delimitation from the part of Ghana in its maritime area, which is also questioned the point of division of the territorial border. But in any case, as a provisional point, while we recover the rest of the continental territory independently, we could also say at the field of the controversy, the continental controversy, Venezuela has rights that cannot be subject, that could not be taken away, and has to be defended based on international law. And that is that projection of the Atlantic front towards the Academy has manifested in that sense that there are mechanisms through these pronouncements that it has given recently, and even the Academy has called to differentiate the defense, our sovereignty, the sovereignty over the sea territories that are a projection of our Atlantic front. As we have said, and the Academy has called to reflect, and it has done it particularly in its pronunciation of in 2015, July 29, something that we consider very important, is that Venezuela found itself in a very uncomfortable position after the reclamation of the sea territory. And it ratified the Convention of the Law of the Sea. And the Academy has called its attention to the need to take upon a legal research with experts, national and international, to see whether it's convenient to ratify these instruments and participate in these in international forums to bring the claim forward. This we say precisely because the participation this is then comes from the participation since Guyana came forward in international forums to pretend to extend their continental path also the continental platform of Venezuela. And simply what we have, we need to revise the situation well. If you review all this pronunciation, and we will keep listening with a lot of attention to the rest of the intervention that will come after me, you will see that the historical position of the academy, the defense of the just reclamation of Venezuela over the continental territory, called Essequibo territory, the claim of the Essequibo territory on the basis of the Geneva Agreement, on its pretension that the arbitral award of Paris is void. So we have then to seek a satisfactory solution for the practical resolution of that conflict, explore mechanism precisely to satisfy that claim, that territorial claim. And then precisely the position of the academy, of the illegitimacy to send this issue to the international organism, that there is not a clause that establishes the competence of the competence of the International Court of Justice over the controversy on Venezuela. So there is a call of attention to attend that legal conflict that is before the International Court of Justice. So Venezuela, as you know, because of the historical documents that the Academy has recovered, it has just motives to reclaim the nullity of that award because of abuse of power, because of the extra limitation that that award has. Definitely, that reclamation, that legal reclamation, legal claim presented forward at the National Court of Justice, we have to attend in, and it will be subject of following of these lectures, but also the Academy, and I think with this, have said that attending that or focusing on that legal claim, the Venezuelan state Venezuela has to defend with a lot of strength the possibility to present countersuit. But the Academy has said that the future, that putting aside the future of the continental territory claim, what we cannot leave aside is the defense of our Atlantic front that take legal actions, strategic actions, diplomatic actions, presence, patrolling, and explaining to the country. Likewise, it has tried different groups, and how the Academy is trying to explain is the defense of the maritime territory, that one is not in this country. With this, I finish my intervention, and thanking Dr. Founders and the rest of the scholars, and of course, who have been listening. Thank you very much for your attention. Thank you very much, Professor Ayala. It corresponds now to Dr. Humberto Romero-Muci, former president of the Academy. You have the floor, Dr. Romero-Muci. Very well, thank you very much. Mr. President and fellow colleagues of the Academy, ladies and gentlemen, professors, students, friends all, good morning. I thank the invitation of my fellow colleagues to participate in this conference about the protagonism of the Academy in the defense of the Essequibo territory. Especially my recognition to the scholars, Héctor Founders and Rafael Badel, for the splendid organization of this event. And as always, our thank you to Universitas Foundation Universitas, for the technical support of this event. I'll start beginning that for the Academy, it's been a priority, historical priority, to defend the integrity of the Venezuelan territory before what the British government in the 19th century and the validity of the award of Paris in violation of this territorial continent. And also the violations of the Corporate Republic of Guyana to the reclamation of the territory of the Essequibo territory in its publications. Generations of scholars of this academy has contributed to the institutional defense and the integrity of the territory. And because of that, it is only just to recognize people as Marco Falcón Briceño, Carlos Sosa Rodríguez, René Sola, Pedro José Lara Peña, Father Germán González, Professor Gustavo Planchar Manrique, Pedro Níquel Belcio, Carlos Ayala Corao, Arria Alan Bruber Carías, Ruan Santos, Rafael Badel, and Héctor Faúndez Ledesma, between many others, among many others. Definitely, it's a very sensitive topic in the country, and it's been obscured by partialized position, an issue with technical and legal considerations, and with trustful consequence for the people and the country. An issue and a matter that all Venezuelans have known and have opinion, and also have heard opinions to not giving legitimacy to this issue, also to reach a consensus on these topics and to decide the action to defend. The Venezuelan claim over Guayana Essequibo is a topic of utmost interest, as has been pointed out. Its earlier background is a cycle of lectures that has realized with the National Academy of History in 1983. And we highlight Isidro Morales Paul lecture in which he presented this the practical solutions to reach a real solution to Venezuela. More recently, in the last 8 years, the Academy has emitted 13 pronunciations procuring the defense of the Venezuelan sovereignty in front of the reclamation of the territorial limit of Guayana Essequibo, and particularly the projection of the Atlantic front. Likewise, it has emitted communications to the Vice Presidency and the Ministry of Foreign Affairs about the need of how the leaders of the country take a position in the defense in the process that Guyana is following in the International Court of Justice to determine the nullity and the invalidity of the Paris Award of 1899, who took the country from its territory. That is why this lecture series on the controversy of the Essequibo that is promoted by the Academy is an opportunity. It's a great opportunity because it allows us to highlight the most important issues and state our legal position over this claim of the Essequibo territory, but also to evidence the institutional leadership of the Academy on this topic in Venezuela and out of the country in the international community, and also to generate conscience over this subject. This Academy has acted with strength and firmness, and also taking positions that have enlightened positions. And I'm gonna do a brief reference to those historical pronouncements of the Academy and a call to Minister of Foreign Affairs. And I'm gonna stop in the most important pronouncement. I'm referring to the pronouncement of 2021, January 13, in which we alert to the ones that represent Venezuela, the importance of the defense of not appearing before the International Court of Justice, given the suit that Guyana presented before that court. So we did a specialized testimony, living memory of the situation of the claim of this. And its main characteristic is the component of reflection that is, and how, and especially in the context of the degradation of the institutionality of Venezuela in the last. In 2011, when Guyana pretended to present a reclamation over the maritime territory without the presence of Venezuela before the International Court of Justice, and also its pretension to extend the border limit to the 350 nautical miles without taking into account the rights of Venezuela, that pronouncement was identified as Dr. Luis Cova and Dr. Ayala Corao. In that same opportunity, the Academy denounced the violations and offensive declarations from the government of Guyana, requesting Venezuela to abandon their reclamation as the only solution to the border conflict, even after Venezuela has kept a position to collaborate and without getting position that those territories and rights were subject to discussion on the Geneva Agreement. In second place, the Academy expressed in October 1st, 2013, its deep preoccupation for the denial of Guyana of good faith to give a solution, a satisfactory solution to the practical resolution to the conflict, trespassing the limits of defense, and as I said, of good faith, to reach concessions over that conflict. So we said also word of the inaction of the Venezuelan government. And we alerted that this attitude has negative legal consequences before international law. In third place, the Academy called the government of Venezuela on the 2015, 29th of July to intensify the patrolling on the front of the Atlantic front of Venezuela, including its territorial sea and economic exclusive zone. And also to reconsider the anti-historical approach that it has been taken at the incurable pending issues because of the inadequate actuation or activity of the Ministry of Foreign Affairs before these conflicts that are contrary to the national interest. And in fourth place, the Academy adverts in 2017 that the pretension of Guyana to judicialize this issue before the International Court of Justice is contrary and deneutralize the Geneva Agreement, which explicit goal was to reach an agreement and to reach a practical solution to solve this controversy that will be satisfactory to both parties. In fifth place, the Academy also said two communications of the Minister to Foreign Relations of Venezuela, March 20, 2017, and the second one in October 25th, 2017, alerting about the need to petition of judicialize the controversy before the International Court of Justice, before the Secretary General of the United Nations, because it was contrary to the both interests of Venezuela, and it was in violation of international law. That was presented without the consent of our country. It was alerted that international law, that the silence of the states have legal consequences that could go to the detriment of the defense of the Venezuelan rights under the Geneva Agreement. And the explicit purpose the Academy is always emphatic in this, that the goal of that agreement, the Geneva Agreement, is to reach a practical solution to the controversy that will be satisfactory for both parties. Through these negotiation mechanisms of the Geneva Agreement that will allow that practical solution. In sixth place, when regrettably the Secretary General of the United Nations sent the controversy to the International Court of Justice, also the Academy gave this pronunciation in conjunction with other academies in 2018, pointing out nor Venezuela nor Guyana has recognized the jurisdiction of the International Court of Justice. It was explained in that moment that none of these states has ratified the statute of that court. Therefore, the decision will be in violation of the Geneva Agreement. Which it has not been considered by the court because it goes against the purpose and principles of the Geneva Agreement, which is again reach a practical solution to the controversy that will be satisfactory to both. In seventh place, when Guyana presented before the International Court of Justice, it stood to recognize the validity of the Paris Accord. We also, as Academy, has a pronunciation in 2019 and called the Venezuelan government to make its argument for the International Court of Justice for that court to recognize the lack of jurisdiction over this issue according to international law. And it also alerts to the consequences of no opposing the exception of lack of jurisdiction before the International Court of Justice. In front of these circumstances, we recognize that who represent legally the Republic it failed to take this position before this preliminary stage things. The court declared its competency, and the Academy again regretted the decision of the International Court of Justice because of these reasons. The Academy said that the Academy does not join and share the decision of the International Justice, but it respects. The Academy call who exercise the power in the country before that international forum that exercise responsibly the protection of the rights of Venezuela over the Essequibo by all means possible. The Academy considered as well that Venezuela has to participate actively in that, even though it is under protest, to defend and to use every single mechanism that could be useful to the Academy. Also alerted that the trial will not stop if Venezuela decide not to appear before that, and that the decision to not go before that forum does not give solution to our controversy. The decision of the International Court of Justice, it was said, is a institutional international fact that it can be addressed, and the position of Venezuela about the nudity of the Paris Accord is sufficiently demonstrated. That the validity of that award cannot be sustained in law. And that is why, and that what the Academy pronounced in these terms. It also pointed out, the Academy, that the International Court of Justice declared, the Academy pointed out that if the International Court of Justice declared that the Paris award was valid, then it will have grave consequences over the Venezuelan rights territory. And that if Venezuela does not present a defense and proofs, it only makes it difficult to resolve. Being this a state business, as we have been saying, we support a decision from the government of Venezuela that will benefit the rights of the state of the country. That has been the point of view of this Academy, insisting in that the country has come together in the defense of its territory. And for that, it is necessary that who exercise the power in the country has that responsibility, historic responsibility, to not criticize this issue. This Academy's corporation identifies also that independently it has to convoke, come together the best experts to form the best team for the defense of the rights of Venezuela. Use the better communicational strategy of this issue that represents the country, the diplomatic activity before the United Nations, before Latin America and the Caribbean, Europe, and the rest of the international community. This corporation has identified that this circumstance should not be seen as a threat, but rather as an opportunity to reivindicate our territory that is in possession of the counterpart. Possibly the firm consideration of these arguments and positions is given its result. Especially in the preliminary meeting of Venezuela before the President of the International Court of Justice to extend a period of 12 months to present, for Venezuela to present its response. In any case, the Geneva Agreement to solve the controversy is still current, relevant. But if this comes forward to the determination of the validity of the Paris award, Venezuela, even though has strong arguments to demonstrate that award is void. If that comes forward, we will be trapped because we consider that's not the appropriate resolution to the Constitution, because that is not the function of just. We should then bring those allegations to an independent tribunal. So we can keep defending the rights of Venezuela before the International Court of Justice. The Academy called once more to authorities to continue to defend the sovereignty of Venezuela and the maritime area and the continental platform that take part of the Venezuelan territory and is subjected to its sovereignty according to the principles of international. The Academy also pointed out that oil concessions to Guyana increases the doubts and controversy and make necessary the actions of affirmation and also other diplomatic actions to defend our sovereignty. To finish, as Secretary General of the United Nations said to announce the revision of this, to send this issue to the International Court of Justice, it mentioned, it's worth to mention that the Geneva Agreement keeps current and is and its only goal is to reach a practical solution to this controversy. So the authorities of Venezuela So it is a call for the authorities of Venezuela to also comply with that Geneva Agreement. We make votes for Venezuela can redirect the defense of the territory of the Essequibo territory in this critical point of history. The defense of our territory is a legacy that the fathers of the land left us, and we could not stop complying. The Academy is faithful to the use of the reason, law, and thank you very much, everyone, for your patience and especially for your attention. Thank you very much, Dr. Romero-Muci. Now, it corresponds the floor to Dr. Eugenio Hernández-Bretón, former president of the Academy. Dr. Hernández-Bretón, you have the floor. Thank you very much. Mr. President of the Academy, members of its board of directors, scholars, audience that is hearing us. I want to, in first place, congratulate this initiative, which is so important to the country in this moment, in this critical moment. I want also to thank the invitation that was given to me to present in this first session of this lecture series. My intention at first place is to briefly mention, which was my responsibility in my period as president of the Academy in 2015 to 2017, and then make some particular comments in reference to my preoccupation of the situation that we currently face in relation to controversy before the International Court of Justice. During my presidency, I had to put my signature to 3 pronouncements of the Academy of Political Science. 21st April of 2013, 7th February of 2017, and also subscriber communication directed to the Ministry of Foreign Affairs, March 20, 2017. In all those communications, we predicted what was the reality. Guyana eventually will present its reclamation to the International Court of Justice, judicializing a reclamation, a claim that it should have been continued through other paths. As you all know, the International Court of Justice gave decision in terms of its jurisdiction to know the case December 18, 2020. The decision count with 12 votes in favor, 4 against. For that reason, the International Court of Justice determined that it has jurisdiction to know the issue that was presented by Cooperative Republic of Guyana in 2018. And that issue is the validity of the Paris Award of 1899. And the issue in relation to the definitive agreement of the conflict, the territorial conflict between Guyana and Venezuela. If we read the 4 votes against, you can find that there are more than beyond reasonable doubts in relation to about the lack of consent of the Republic of Venezuela to have interpreted at the end of Article 4.2 of Geneva Agreement. In particular, it calls attention reading of the Russian judge, because it shows the deficiencies of that decision of December of 2018. Also, you have included that decision paragraphs that are very difficult to understand, which more than a legal explanation are justifications to assume jurisdiction. I call attention to paragraph 86 of the decision. The Geneva Agreement does not mention not once the International Court of Justice. But never the Geneva Agreement mentions or includes or excludes a reference to the International Court of Justice. And nonetheless, now any difference with the content of this decision places Venezuela before the dilemma to what to do now. And what to do now is a task that the Academy must take upon. On February 26th of this year, Venezuela, through its representatives, participated in a meeting of the International Court of Justice. Venezuela expressed that is considering its participation in the process, but it hasn't decided. And constitutionally, its participation require public consultations, and that will take time. March 8th of 2020, the International Court of Justice set March of 2022 for Guyana to present its memorandum, and sets 8th of March of 2023, so Venezuela can present its defense memorandum. Those are the immediate tasks in relation to the pending procedure before International Court of Justice. With this, I don't want to left aside the other fronts that are open but now that's what Venezuela is facing. So now, which issues we should consider in relation to the continuation of the procedure before the of December 2020, and for some could be seen in entirely favorable or not favorable to both. However, to let you know how this decision was received in Guyana in December of 2020, the president of the Cooperative Republic of Guyana, it praised the decision of the International Court of Justice. But then there were also critics within Guyana, because there are two main issues in which the discussion is sustained under the jurisdiction, under the International Court. First, the issue of the validity of the award agreement of Paris 1899, one part, and second, the issue related to the limits, the border between Venezuela and Guyana, 2 issues. But those 2 issues should not be discussed by the International Court of Justice simultaneously. Here, I call the attention to what it was highlighted, in particularly in one declaration of the Judge Tomka in its dissident votes. He said that now it has opened the opportunity for both parties to substantiate its contention that the Paris Agreement is void. That is also being recognized in the last part of paragraph 86 of the decision of the, December 2020. And there it says, it is sufficient for this court to observe that in this case, one of the judicial decisions that a Paris award is void without delimiting the border between the parties, it would not conduce to a definite resolution of the controversy, which would be contrary to the text of the agreement. One thing to take into account is the future that Venezuela faces, the procedure before the International Court of Justice. In that same vote of Judge Tomka, paragraph 7 of his decision, it is important that the parties understand that if the arbitration award were to be declared void by the court, as Venezuela is saying, the court will need more presentation in forms of arguments and proofs in relation to the border limit, to that way, so definitively the controversy. Without this presentation, the court will not be in a position to determine the disputed border between the countries. This could be called to exercise its authority under the Geneva Agreement to choose other means of other channels to resolve. And this one is again repeated by the judge, the Moroccan judge. And even though the court will determine that the award, arbitral award is void, it will correspond to the parties in any case to present the necessary conclusions in the relation to their limits and the dispute that it will still remain between them. This is why, and for that it will be necessary to choose other of the Pacific mechanisms. But then the response could not be other to the decision of participate or not participate. Venezuela must participate. If one reads the dissident vote of George Orwell, that there was not sufficiently considered the arguments presented by Venezuela, that it were presented to outside the procedure. They were not considered nor the proofs or the arguments. Venezuela lost the chance, the opportunity to defend it. Venezuela must not lose again opportunity to defend. It has a duty, the government has a duty, historical duty to formulate its allegations and formulate the defense of Venezuela. However, this is not an easy task. We are against time. We have until the 8th of March of 2023 to prepare the draft, to prepare the defense, to get to know next March of the allegations of Guyana and their proofs. There's not much time. There's not much time because we have to build a team that must be integrated by historians, experts in politics, by lawyers, by people that are not knowledgeable about this issue. That they know the secret, that they know everything that happened in this issue. We have to define a strategy, a legal strategy for this. Have we even asked ourselves about the nullity causes that is not written anywhere? That comes from doctrine, jurisprudence, case law, but this is a very particular case that Venezuela has. Who will have the responsibility to prove? Which proofs do we have? which allegations are we gonna make? Are we gonna argument corruption? Are we gonna argue problems of the consent, a lack of motivation, abuse of power, lack of jurisdiction? Are we going to argue processal fraud? Are we going to attack the validity of the Washington Treaty of 1897? We have to think about that. If we succeed in winning the subject of the arbitration award, we have to think also that the issue of the border is still open. Are we going to go back again to the system of the Treaty of Washington with arbitration panel, with a panel of arbitration that includes English and Americans? Are we going to go back to that? And we have to anticipate the defenses of Guyana. We have to take front to the defenses of Guyana. The Venezuelan attitude must be the defense of Guyana. Let's not contribute. We have to carefully examine the statute of international corruption. We have to examine the Venezuelan border. We have to examine the Venezuelan border with Brazil. We have to examine the Venezuelan border with those countries and of those countries with Suriname. Suriname already submitted its border controversy with Guyana and how that will impact our controversy. There is a research and a study because the Ministry of Foreign Affairs got to preoccupy about that important research and a great internationalist of Venezuela. That was El Dr. Ramon Carbon. And he took care of the subject of nudity. That has to be on the papers. We have to recover that. There is a file. There is a bibliographic material in there that can help the Venezuelan people. And I want to close, I want to finish reading a journalist declaration given to the newspaper El Nacional, 1966 in February, by a man that from very young age dedicated himself to this issue, the problem of Guyana, of the Guayana Essequibo, how he likes to call. And that continuing to study this, he died among maps. I'm gonna read it. The last men that respond to critical hours are those who had taken towards themselves for critical circumstances or personal circumstances, the dominance of the transcendental problem as it is the recovering of the state. And that's the same very task that corresponds to this corporation, to the academy. Thank you very much. Thank you very much, Dr. Hernández-Bretón. Thank you very much to all presentations for their brilliant presentations and to go deep into the reasons that assist Venezuela in this controversy. We're gonna open now a brief space for questions. We have two at the moment that we have on the chat. The first one. According to the map presented by Dr. Ayala, what can be done about the sanctions that have been conducted by Guyana in regards to the exploration of maritime space? This is a question for Dr. Carlos. Thank you, Dr. Faundes. Well, it is important, this question, because as we said before, and from the intervention of all the scholars here, well, we defend the recovery of the continental territory, the Essequibo, we cannot lose sight of the maritime territory, the sea territory. We are in front of a solution that there's no delimitation of the maritime areas, because Venezuela aspires that Punta Playa Point is a provisional point that, given the recovery of the territorial continent, we can have a more broader extension of the territorial continent that allowed to project that into the territory. However, the position has been, independent of the future of the reclamation, the claiming of the territorial Essequibo, and we take the point you saw on the map, the delimitation that the international law allows. So it is unacceptable that the economic exclusive zone and the continental platform is giving concessions to for oil exploitation. That some activities has been taking place through flea vessels. That those flea vessels, independently of the flag, that are doing activities in that territory. Those are areas that must be patrolled, as it has been in the past. There's a zone that must be patrolled by the Venezuelan army, and any incursion must be responded as a diplomatic response. Any act of invasion of that nature zones must be correctly addressed and denounced, not only bilaterally with Guyana, but also to the level of United Nations, for the general knowledge that corresponds to the Secretary General of the United Nations. But that implies, at the same time, series of actions, a proactive action. And among those proactive actions of protection of that area, Venezuela should also control the blocks of exploitation and exploitation. It has to claim to the Chinese enterprise that have business with Venezuela associated in the exploration and exploitation of that block of resources, and has to resume a series of actions and interaction of relationships with the international community, which of course Venezuela is not in its best positions, because it has lost alliances in the hemisphere. So this is about to make not only defensive actions, so proactive actions of denounce, of defense. And in this case, not only law is valid, but also politics in the international sphere. And with this, I conclude. A big country like China, which is allegedly a partner of Venezuela, is at the parallel receiving a concession of exploitation in that same area dispute. So that should be a claim as well. That will be the position to defend not only from the legal point of view, but also at the same time a proactive defense of protection, because our greatest fear is that with a passive attitude and with all those elements that we have talked today, we could end up losing to what today is not in dispute. But Guyana has pretended to put that on the floor, closing the protection of the both channels coming from the Orinoco River. Thank you very much, Dr. Ayala. There are other two questions. These questions are for Dr. Luis Cova. First, even though this is not the order they were asked, what is the meaning of Iutis Possidetis Juris that was invoked by Venezuela? Also for Dr. Cova. Could Venezuela reconvene in the trial before the International Court of Justice? Thank you. With respect to the first question, what significance has the Iutis Possidetis Juris invoked by Venezuela? Iutis Possidetis Juris is historically linked with the emancipation of the provinces before the Spanish colonies. It is a cease of the vice reign of Spain, requesting the limits of the space, territorial space that it commanded at the point of 1821. So it affirms itself as successors of the Spanish crown. And that way we have two decisions of the Swiss Confederation about the border conflict between Venezuela and Colombia and between El Salvador and Honduras that determine that same criteria. It is a preeminence of the title that we have. That is what it is, the Iutis Possidetis. Now, the other question, could Venezuela reconvene before the International Court of Justice? Well, what is being said, the defense of Venezuela is to demand that the negotiations will be taken in a good faith, according to the Geneva Agreement. Thank you very much. If you're allowed to add some comments in relation to the Iutis Possidetis, according to international law, is a principle of reivindication. Borders between countries that came from the same colony empire. In any case, we'll have to see what the International Court of Justice decides about that. In any case, I want to remind everyone who is following this colloquium that on the fourth lecture of this series, we are going to talk about the rules of the Treaty of Washington. And there, we're going to have the opportunity to listen once again to two of our presenters about the titles that could be invoked by the parties in this controversy, and they could have been invoked previously by Spain or by England. In relation to the second question, in terms of this reconventional suit, that was pointed out at some point, at least among who we have talked about this. But this could only be presented before the International Court of Justice decided this controversy in December. But now that the court has pronounced about its jurisdiction, and now that the court has determined the object of the controversy, there's no place for this kind. But Venezuela could insist in the application of the original court. If now that the court has determined that it's competent to know the controversy, then we'll have to take into account our obligations of the Geneva Agreement. In any case, it's something that is an issue that is pending, and we will see further discussed in the next sections of this lecture series. I have more questions in the chat from participants. I want to point out that with this act, we have started a cycle of 12 colloquiums in which we will hear the voices of very qualified experts, national and international, in relation with each of the points of the facts, historical facts, legal of this controversy. You are all invited to join us through this lecture. Since there are no more questions, we thank the excellent panel that we had today. And I give the floor to the president of the Academy for him to conclude this event.
Muchas gracias a los participantes en este acto, muchas gracias a los que nos han acompañado y han dado a la Academia la oportunidad de compartir con ustedes un tema de interés nacional y un tema que forma parte de la historia de la Academia. Como señaló el doctor Faúndez, estamos comenzando un ciclo ambicioso de coloquios en el sentido de tratar de informar y mantener informados a todos ustedes sobre la posición no solamente de la Academia, sino de las personas que han trabajado en el país del tema, con el objeto de que todos tengamos una idea clara de lo que tenemos por delante. Quiero agradecer adicionalmente a Universitas por el esfuerzo realizado en este acto, a Mariana Escolaro por la traducción, por las innovaciones que Universitas le ha aportado a este acto, y quiero felicitar muy particularmente también al doctor Faúndez por el esfuerzo realizado y por el comienzo exitoso de un evento como este, que sin lugar a duda va a ser un factor importante en la información de muchos venezolanos con respecto a lo que tenemos por delante. Doy por finalizado el acto y que tengan todos ustedes un feliz día.